Greetings and welcome to 5 minutes or so with Dykema on what clients should be aware about, what's happening in DC inside the Beltway on the labor and employment law front. I'm Rob Boonin. I'm a labor and employment law attorney in our Ann Arbor, Michigan office.
And I'm Jim Brandell, and I'm with Dykema's Washington, D.C. office and their government policy practice.
Jim, there's so many issues that are going on in the labor and employment law front in DC, and we're only going to try to tackle one of them today, and that's what is going on with independent contractors. This is somewhat of a technical issue, but frankly, I think the clients aren't really paying enough attention to this issue because, as it evolves, it could have dramatic impact on the way that they do business and who they do business with. So even though the legal issues are somewhat technical, the practical impact, I think, could be huge. And the question is, who is an independent contractor? If you're an independent contractor, you're not subject to many labor laws. You're not subject to a lot of tax laws either for those individuals doing the work. But if you misclassify someone as an independent contractor who the federal government thinks should have been classified as an employee, all of a sudden you have other liability concerns, both on the tax, unemployment, workers' comp, things like that. But the huge liability that I focus on more often, the consequence that we're worried about more often is that on the how it will affect their entitlement to overtime pay. Because independent contractors right now can work all the hours that they want, doing everything that they want to do, totally, at their discretion, without us telling them to stop or to start because they're independent contractors, but they don't get overtime for working over 40 hours. It's their choice. But guess what? It may be their choice, but if they become employees, then all of a sudden, people that we thought were independent contractors or employees, we're now liable as employers instead of contractors. We're liable for their extra work. And I think that, frankly, the Biden administration is set up to radically change the standard and thereby make many contractors all of a sudden flipped. One day they're a contractor, the next day they're an employee. Not only the next day will they be deemed an employee, but looking back 2 or 3 years for unpaid overtime, they're going to say, I was an employee for all those years, show me the money. So I think that's going to be a problem. And it's going to, if it changes, I think we're going to jeopardize the way things operate going forward. Jim, is this something that's in your radar?
Absolutely. We all have seen some of the state issues kind of play out when it came to the ballot proposal in California on Uber and Lyft, but it really goes far beyond that, as you know, Rob. This can touch all industries in so many ways: financial services, real estate, franchise. This is an issue that, like you said, is probably not getting enough attention, but it's starting to boil up in Congress, and employers and business owners and franchise owners are really starting to come to the table and talk to the policymakers about this, because what the new DOL is going to do on this could really reshape the way that employment law goes forward, and it could have some very negative consequences if people aren't ready for this, or if it goes forward.
Yeah, and I think there's many players that we have to worry about here. All right, there's the Department of Labor, then there's going to be Congress, then there's going to be the Supreme Court, and there's going to be the way the lower courts interpret the law, and what is what is the status quo? And the status quo actually has been, I think, fairly well established for decades. It varies a little bit depending on what circuit court your business falls in, but basically there's an economic reality test, and they still say if it looks like a contractor, smells like a contractor, talks like, walks like a contractor, it's a contractor. What happened though, and I think the history is instructive, is back during the Trump administration, the wage and hour administrator kind of put a whole new spin on it, and it came out with a guidance. The wage and hour administrator at that time was a guy named David Weil. Remember that name? I'll mention it again in a minute. But David Weil came out with a guidance that purported to be basically a summary of the law, but it was a summary of the hardest standards for employers to satisfy, and he also said that you had to satisfy all these standards. So if a company provided a tool, no longer an independent contractor, you're an employee. If the company set when the work is going to be done, the company is now an employer, and the worker's not an independent contractor. There are all these things that he came out with this guidance for, that really, in my view, turned the whole legal standard on its head. So the courts had to deal with this a bit, back during the Obama administration, and the guidance wasn't that well accepted by many courts. But what happened is, when the Trump administration took over, one of the first things they did is said, hey, we don't need that guidance. We'll just let the courts do what they're good at doing and interpret this. And they did that for a while, but eventually the Trump administration, knowing that they would not be in office forever, and this is what administrations start to do, as they come up with a policy that they think they want to have a longer life, they extend the life by making it into a regulation, because once it's a regulation, you have to go through a process that could take years to change a regulation. So what they did toward the end of their administration, in January of this year, they came out with a regulation on independent contractors that basically adopted what the courts have basically held to be an independent contractor. They've reduced the 6 or 7 standards that David Weil wanted to be the standard to look. If you satisfy 2 standards, that's good enough proxy. We can go beyond that if we need to, but it's pretty much what the courts have always done. But they memorialized it in a regulation. They did that in January, and but the regulation wasn't set to go into effect until March. And when a new administration takes over, they have a power to push a pause button. They pushed the pause button, and they extended that March date until early May. And basically, the day before it was supposed to go into effect, they withdrew it. They withdrew the rule, and now we have, I guess, a blank slate, at least officially, from the Department of Labor. We don't have a guidance, and we don't have a regulation. But Jim, what are we going to get?
Well, I mean, because it's a blank slate, now is actually the time where people need to come and get a seat at the table when it comes to this regulation and what may be coming forward. As you said, David Weil has an agenda that he's pushed in the Obama administration. So,
all right. I said you were going to mention that name again. David Weil is President Biden's nominee to be the new H&R administrator, to take the same job that he had back when he was in the Obama administration. So that's why the writing is on the wall, that he's just not going to let this thing sit.
Exactly. And as we know, his nomination, pending any, a major surprise, is going to make it through the U.S. Senate for Senate confirmation, and he will be in that position at the Department of Labor. And so employers are really starting to take notice of that and start trying to talk to their legislators, talk to policymakers about how a potential rule could be shaped. And really now is the time where folks need to come to the table. And that's what we do here at Dykema in our Washington, D.C. offices, really help people navigate and help with the advocacy when it comes to, what is important to an employer in an area. That's gold to an employer to know what that, or to a member of Congress to know what that's about. And so I really encourage people to step up and not be passive when it comes to, these rules, thinking that, these things happen without any input or they don't have any power when it comes to it. That's not the case. Folks, regardless of their size, when they talk to their policymakers, it's like gold. It really is, when they hear from them on what their employers are doing and how many employers they have, and what the rules and regulations need to be. And those members of Congress can be an advocate for you to make sure they're shaped the right way with the Department of Labor. And we do that very often with members when it comes to submitting comments and meetings and so forth, to really help shape some of these things to be a little bit more palatable. So it's really, there can be a win-win at times.
You know, what I'm hearing is don't be passive, be proactive. And
Absolutely.
I think that's a good message. But in the meantime, employers should look at, you know, who are we treating as independent contractors now? And would they survive a David Weil test? And actually, are they properly classified now? And if they're not, then, you know, what's the best way to update their status, if you will, how to do business with them, or change your business structure moving forward. And then, you know, I'm always talking to clients about that issue.
Well, they should definitely reach out to both you, Rob, and me, and we can sit and do an assessment with them and figure out what's the best strategy. But it's best, like you said, not to be passive, to be proactive, because later this year we're definitely going to be seeing some proposed rules from the new administration.
I think that's all we have time for today. Hey, it was good seeing you. See you again soon.
Thank you.